So, good afternoon, ladies and gentlemen. I'm Alasdair Burnet. I'm the Stable Director of Terra Firma Chambers. It's my pleasure to welcome you all here today for the joint conference held by Terra Firma Chambers and Solar on common good, which I think is, although an ancient topic, one of much interest at the moment. First of all, just the practicalities. There are no planned fire alarms today, so if something goes wrong or there are loud noises, the fire exits are both behind me. Good news is, hopefully tomorrow, and that is the plan, you'll receive slides and handouts from the speakers, so there's no need to take copious notes, but if you wish to, you can do so. And also there is a health warning that we're also, although not online live, intending to record this seminar as well. So any of you who've been watching the Ryder Cup and saving up your best heckles, can you please keep them appropriate and as clean as possible for those who may wish to watch later. So without further ado, we're going to split it into two sessions. There'll be a coffee break approximately about 3:15. Terra Firma members are going to take the first half of the conference, and then Rob Mackenzie and Andrew Ferguson are going to do the second part of the conference. So first up, we have a joint presentation by Mark Lazarowicz and Francesca Glendinning, which they described a bit like common law. As Mark said, some of it was like time immemorial and some of it was quite modern. I think Mark's going to take the longer standing, more experienced part of the talk, and Francesca the more modern. Francesca being one of our newest calls and practicing previously as private practice and then with the Scottish Government Legal Department. So like many of you here today and many of the speakers have seen common law and other aspects of local authority law, both from the perspective of private practice and through public sector work as well. And I think Mark may well be known to many of you as well. He is a practitioner of long standing, but also a person who has experience of local government and indeed national government from the government side as well as the legal side of the law. So I first ask Mark to speak to you. Thank you.
Thank you very much, Alasdair. In this talk, I will outline the basics of common good law, as you will see from the title slide, first by describing the concept and then setting out the essential legal basis on which good law is constructed. Although this is an area of law which can be regarded in some ways relatively limited in terms of case law and legislation, I'm sure that you will nevertheless appreciate within 15 minutes, 20 minutes or so, I will only be able to present a basic outline of the law. For those who do wish to pursue a topic in detail, I recommend you turn to the standard work on the topic written by Andrew Ferguson, one of our speakers later today, and from whom I acknowledge some of the sources of the ideas for my talk today. Many of you here I know from the list of attendees have had considerable experience in common good matters, and my talk may not therefore add too much to your existing body of knowledge, but I trust this talk will be a benefit to those of you with less knowledge and experience in this area, and of course may also be a helpful refresher to those who have more long-standing experience. Let me turn to the basic concept of common good in common good law and its historical origins. Common good law is about common good property. Common good property is certain property held by local authorities. It is not property which is held by some form of trust, which the local authority or some of its members hold as trustees for the authority or for some other community body of interest. The case which at some length set out some of the principles is the case of the Rothin Castle case there, somewhat wide range of subject matter considered in that case, but it's quite useful for discussion about when common property might be the property of a local authority trust, whether it is common good property. Now, such local authority trust or trusts for which local authorities are trustees do exist, and there has frequently been confusion certainly in older times, over whether some property was held in a trust or by the local authority in its own capacity. To decide such a question, it will normally be necessary, as you would expect, to examine the relevant title, and they may include not just dispositions, but also trust deeds, borough charters, and perhaps evidence such as the minutes of local authority meetings. Common good property can best be regarded as the property of a local authority, which is held by them under a special legal regime, but ultimately it belongs to the local authority. It doesn't belong to the local community, as I know is sometimes thought. There are specialities as to how the local authority common good property can be disposed of and how it can be managed. But apart from those, the general rules as to how a local authority manages and can dispose of its property, for example, in the application of rules regarding best value or good practice in decision making and the like, apply to common good property as much as it does to any other local authority property. Common good property may be either movable or heritable. Most common good property is heritable, and certainly most legal questions about it have arisen in cases where heritable property is concerned. However, many instances of movable common good property certainly exist. Typically, these may be civic regalia inherited from local authorities, the Lord Provost chain, antique furniture, works of art, and the like. There may no doubt be other items in storerooms or even in daily use, and it's reasonable to assume that there'll be some such items held within the common good property of a local authority in Scotland. Disputes over such property rarely arise, however, at least legal disputes anyway, and I will pass on to the questions concerning heritable common good property, which have featured most frequently in court cases, and which arguably perhaps more frequently so in recent years due to a combination of greater awareness of common good property and recent legislation on the subject as well. Common good land holdings in the possession of local authorities today derive principally from the common good held by former boroughs. A list of those boroughs can be found in a schedule to a Local Government Act 1947, which is listed in the handout which you will get sent to you. And you will see there that the boroughs are divided into large and small boroughs, and there are also counties of cities, the four major cities, which are included within the list of that type of local authority. So most local authority heritable property, which is situated outside the area comprised by one of those boroughs, is unlikely to be common good property, although it may be if it was derived from other types of local government unit, for example, various specialities such as boroughs of barony, police boroughs and others, which existed in previous times gone by. It's also worthwhile remembering that the common good property of one authority may be located theoretically, and in some cases in actuality, outside its boundaries. I don't know if it's the case, for example, but it'd be possible if Edinburgh could well have common good property, perhaps in Musselburgh or something like that for some historical reasons. I don't know if it's the case, but that can happen on rare occasions. When will local authority be part of the common good? The basic principle was set out in the case from which I've quoted here. Again, that's the Ruthin Castle case, or maybe Ruthin Castle, and that is, as you'll see in the first section, that all property of a royal borough or a borough or barony not acquired under statutory powers or held under special trust forms part of the common good. And that sounds pretty wide-ranging, as indeed it is. But as you will see, there is the important exception. Property acquired under statutory powers is not normally something which forms part of a common good. There are also some special exceptions in that case, which you will see are set out there, which also indicate where some property may not actually be in the common good, and that's perhaps a particular speciality which won't apply in many cases. So what will be the borough property which falls within that common good because it's not within the excluded category of being acquired under statutory powers or because it was in reality held in trust? That question has to be answered by considering from where the ownership of that property has been derived. And in that context, I'll also mention that buildings, etc., erected in common good land will also normally become part of that common good property by application of the principle of accession, as a recent cases confirmed, which I know Scott will be covering in some detail later in his talk about a particularly important recent case. So if all property of a borough, with some important exceptions, is common good property, or was common good property, how did the borough get that property in the first place? Well, there are two cases which are useful in setting out how that common good character of a property was acquired. The first one in this case, Murray, very important one. There are at least three ways in which a public use of borough property may be acquired. The land may be appropriated to public uses in the charter or original grant. The land, after it's become vested in the public body, such as a town council, may then be irrevocably appropriated to public uses by the act of the town council itself. And again, it may be so appropriated, or rather the inference may be drawn that it was originally appropriated to public uses from evidence that the land has been used so and enjoyed for time immemorial. So original charter or grant, dedication to public uses, or use and custom on time immemorial. Another more recent case than the Murray one, which underlines the approach, is this case from Cockenzie and Port Seaton against East Lothian, a 1997 case. The conclusion which I've reached, I should follow the broad approach exemplified by the observations of Lord Walk, and that was the Lord Walk's comments about all land of a borough is common good except for statutory exceptions, one other exception. But it's useful because it gives an indication of a kind of property you can expect to be included in the common good holdings of an authority. Public lands are buildings, churches, town halls, marketplace, common greens or grounds set aside for general use or enjoyment of inhabitants and so on. Now, it's not the case that all these buildings of this nature are part of the common good, but this is typically the kind of common good property that you will come across and you will see as the subject of dispute. In essence, local authority property acquired from former boroughs is likely to be common good property unless certain exceptions apply, if it derives from one of the following: from royal charter or other method of creation, from gift, donation or dedication, or custom or time immemorial. To find out whether any of those categories applies, then you will understandably need to look at the title under which the local authority and its predecessors has acquired the property in question. First, you might get a royal charter of a charter, a baronial charter, or sometimes statute, which will specify the grant of an area of a land to a borough. It may not be clear as to the boundaries, and reference may be made to extrinsic evidence if there was a question as to what those boundaries of the land in question are. Such old charters will, you'll be pleased to hear, no doubt, may sometimes be in Scots, so rather than in English, and occasionally they'll be in Latin as well if you want a real challenge to understand the area in which you're dealing. The one which is probably most commonly the subject of particular disputes or legal cases will be ones which set out a grant of land for the common good. Here's a typical one, which again is quoted, I think, in Andrew Ferguson's book, their case from Hamilton, which is a typical wording from which you will be able to deduce that land has been dedicated for the, as you will see there, the community of a said borough, for the behoof of the whole body and community of a said borough. You will see that towards the end of that quote, there's a line which says, "The same shall be held in trust always for the behalf of and solely for the use, recreation, and enjoyment of inhabitants of a borough. Sometimes you will find, or quite often you will find, that there may be elements of a wording of such a grant which indicate that there is an intention, there is a possibility that the grant may be the grant to be held in trust, but the fact the word trust is there doesn't actually mean necessarily will be a trust. You have to look at the whole circumstances, and here what is crucial is that it's a grant of land to the community of the borough for the behoof of the whole body and community of the said borough. So you need to look at these very carefully to discern the meaning. Custom and time immemorial is one which again can be important, and that will normally require evidence about use over a lengthy period of time. But you'll also need to look at, no doubt, at the documentary evidence, including what title deeds there are for the property, and for minutes or reports from a local authority or church records and many other possible sources as well. Now, there's an important exception, which I think sometimes is not as widely realized in practice as people ought to appreciate, and that is the acquisition that generally land will not become part of a common good. It was originally acquired by an authority under statutory powers. Now, local authority statutory powers to acquire land and property in the last half century or so have been ones which tend to grant powers in fairly general terms. But prior to that, and that's important when you're looking at older property holdings, you would find there were specific acts of parliament which would grant powers to local authorities to undertake various activities, so education, recreation, or whatever. There's again a long list in Andrew's book there, which I recommend. Here's a few examples of legislation under which many areas of land will have been acquired by a local authority and will therefore almost certainly not be part of a common good. One thing I would also mention is that there are a number of acts of parliament from the 19th century, Borough Police Scotland Acts, which are actually not just about police stations. They're very important because they are acts of parliament which grant quite wide powers to certain local government institutions at that time, local government bodies, which can thereby take out some land from the common good definition. One point to bear in mind is when a local authority, today's local authority, which has inherited the common good from the previous boroughs, is that when property was transferred to current local authorities under the 1994 legislation, that property which is transferred, and if we look at paragraph 4A, except in the cases of the councils of Aberdeen, Dundee, Edinburgh and Glasgow, have regard to the interests of the inhabitants of the area to which the common good related prior to the date, which is when the new authorities in 1975 acquired the common good property. And in the case of the councils of Aberdeen, Dundee, Edinburgh and Glasgow, have regard to the interests of all the inhabitants of the areas, presumably because those are fairly closely geographically defined. So it's important to bear in mind that if you have a local authority common good fund or a collection of property which is derived from a number of different historical boroughs, as it almost certainly will, that in managing those, the local authority has to have regard to the interests of the inhabitants of the area to which the common good related prior to 1975. Now, in my view, that doesn't mean that you can only use that bit of the account just for local authority A, or the bit from local authorities B historically just for area B or whatever. But it does seem to, because the provision is have regard to the interests of the inhabitants of area. But I do sometimes wonder whether practice, which is common in many authorities, or has been, to lump all the common good funds into one bank account and then allow anyone in the area to apply for grants or expend it from it. I do have some doubts as to whether that is always entirely consistent with the provisions of the legislation in 1994. Now, the final couple of minutes of my talk deals with the matter which is probably of most daily concern to those of you in local government who come across local issues concerning the common good, which is when are you allowed to dispose of or change the use of the local, of some element of local government property. And you will find the legislation set out in a section in the 1973 Local Government Act, which I will briefly make a couple of comments. This section, subsection 1, the provisions of this part of Act with respect to the appropriation and disposal of the land belonging to local authority shall apply in the case of land forming part of a common good of an authority with respect to which land no question arises as to the right of the authority to alienate. So if there's some common good land and there's no question that the authority can alienate, that's dispose of, to be put it very briefly, then the rules regarding the disposal of that land, or the appropriation of that land, are the same rules that generally apply to local authorities who want to dispose of or use their land for other purposes. You will see there the reference to appropriation or disposal. Appropriation in broad terms means a local authority using common good land for another function than its current use, but not transferring the land out of its ownership. And disposal is a transfer of land out of the hands of a local authority by sale, lease, or by other methods. However, if a local authority wants to appropriate a dispose of land in which a question arises as to the right of the authority to alienate, they may apply to the Court of Session or Sheriff to authorise them to appropriate or dispose of a land, and the Court of Sheriff may then authorise the authority to appropriate or dispose of a land subject to such conditions as they may impose, etc. And there have been numerous cases over the years, not surprisingly, because this is the occasion when the courts are most likely going to be asked to decide upon a subject, numerous cases to how this particular provision will be applied. It's very much a situation where it depends on individual cases from time to time as to how it will be applied, but you will note that the court has the authority to impose numerous conditions. Sometimes the court will just simply allow a disposal without any conditions. Sometimes it may make conditions regarding where the use of the funds which are obtained from the sale of common good land, they make rules about that, or they can, and this is the final comment that I want to make, a final section I want to refer to, the Court of Session or Sheriff can also make provisions that the authority shall provide in substitution for land proposed to be appropriated or disposed of other land to be used for the same purpose for which the former land was used. For in practice, I don't think that provision is very often made use of. So that concludes my quick whistle-stop tour of the basics of most of common good law. And I will now pass over to my colleague Francesca Glendinning, who will speak about some of the more recent innovations in that area.
I'm going to now look at Part 8 of the Community Empowerment Scotland Act 2015, which makes provision in relation to common good property and aims to increase transparency about common good property and community involvement in decisions taken about the identification, use and disposal of common good property. As you'll see from the slide, Part 8 of the 2015 Act is quite short, extending to just 5 sections, including an interpretation section. The provisions do not define or redefine common good property, nor do they remove or alter any restrictions on the use or disposal of common good property. Equally, the provisions do not make a distinction between alienable or inalienable common good property, and as such should be taken to cover both. The provisions within Part 8 of the 2015 Act came into force in June 2018 and placed two new duties on local authorities in relation to common good property. First, in terms of Section 102, local authorities now require to establish and maintain a register of common good property. And second, in terms of Section 104, local authorities must publish their proposals and consult the relevant community council and community bodies before disposing or changing the use of common good property. Sections 103 and 105 require local authorities to have regard to any guidance issued by the Scottish ministers in relation to those duties. The Scottish Government published statutory guidance on how local authorities ought to carry out the legal duties imposed on them under the 2015 Act in July 2018, and I'll come on to discuss a particular aspect of that guidance shortly. Now, given that most local authorities will long since have established a common good register, the focus on my talk today will be in relation to the duty on local authorities to consult in terms of Section 104, which is shown on the slide. From this, we can see, or at least those who have 20/20 vision perhaps can see, that Section 104 applies where a local authority is considering disposing of any property which is held as part of the common good or changing the use to which any property is put. Section 104, subsection 2 provides that before taking any decision to dispose or change the use of such property, the local authority must publish details about the proposal, with subsection 3 providing that the details may be published in such a way as the local authority may determine. On publishing details of the proposal, in terms of Section 104, subsections 4 and 5, the local authority must notify and invite representations from any community council and community bodies. Section 106 of the 2015 Act defines both community council and community bodies, with community council meaning a community council in terms of the Local Government Scotland Act 1973, and community bodies meaning bodies, whether formally constituted or not, which have been established for purposes consisting or including that of promoting or improving the interests of any communities, however described, resident or otherwise present in the area of the local authority. Finally, and again, as we can see from the slide, Section 104, subsection 6 sets out that in deciding whether or not to dispose of any common good property or change its use, the local authority must have regard to any representations which are made. Scott is going to cover in his talk what might constitute a disposal or a change of use for the purposes of engaging Section 104, with reference to a couple of cases which have considered this issue. And so I'll now turn to the statutory guidance which local authorities are required to have regard to when they are planning to dispose or change the use of common good property. As is set out on the slide, Chapter 5 is the relevant chapter of the statutory guidance, and this sets out how local authorities ought to undertake their duty to consult under Section 104. The guidance provides that in terms of where and how the details of the proposal should be published, members of the public should be able to view any proposal on the local authority's own website, and that local authorities should also ensure that members of the public can view the proposals in person at local council offices, council hubs and local libraries. Insofar as advertising is concerned, the guidance sets out that local authorities should publish any consultations on their websites, on social media or in publications which they produce, and that where the proposal is likely to affect a large number of people, the local authority may also wish to consider advertising in the local press or holding public meetings. If the proposal relates to a building or an area of land, A public notice should be placed on the building or on the land or on an object close to it. And if it is a building which is open to the public, the local authority may also want to put a copy of the notice somewhere prominent inside. The guidance makes clear, however, that it is more important that the notice which is put up in a location where interested people will see it, rather than it is necessarily on or adjacent to the property in question. For example, a notice could be displayed in a village shop, on a community board, or an information point in a car park, wherever local events and notices are normally advertised. In terms of the information which ought to be included within the proposal, the guidance provides that the proposal should clearly state which property the disposal or change of use relates to, the exact change which is being proposed, as well as details of likely timescales. The local authority should also ideally use the same information about the property which is included on the Common Good Register. In relation to cash funds, the guidance sets out that a change of use would not necessarily cover making payments to different people or moving investments around, but would include, for example, changing the rules about the type of thing that could be funded. Turning then to consider inviting and responding to representations, the guidance on this topic sets out that local authorities should allow a period of 8 weeks from the date of publication of the proposal for community bodies and others to make representations, and that local authorities should also make clear when inviting representations that all representations will be published to ensure that the process is carried out in a transparent way. Local authorities should then aim to consider and respond to any representations within 8 weeks of receipt and publish both the responses alongside the original representations, in addition to the final decision about the proposal, in respect of which the local authority should also notify to any person or body that made a representation. The guidance finally sets out that where a local authority decides to amend a proposal, either in response to changing circumstances or the representations which have been received, and the amended proposal is materially different from the original proposal, then a new 8-week consultation period should be carried out. In terms of a couple of final comments on the duty to consult in terms of section 104 of the 2015 Act and the statutory guidance, I think it's worth noting that whilst local authorities must have regard to the statutory guidance and any representations which are received, it is ultimately a duty to have regard to the guidance representations and no more than that. But in saying that, however, given that it would be open to the court to consider the adequacy of any consultation process which has been undertaken as part of their consideration of an application by a local authority to dispose of common good property, even where an application is unopposed, in my view, local authorities would be well advised to closely comply with the guidance, as showing that a thorough consultation process was undertaken may be of some importance in persuading the court to grant an application. And in this respect, a comprehensive and well-recorded consultation process will probably always be desirable. And with that, I'll hand over to Scott.
Thank you, Francesca. Our third speaker this afternoon is Scott Blair, who's well-known and very long-standing practitioner in all areas of local authority law, in particular interest in licensing, but also now a particular interest in common good law. And having had the basics of the sort of background and context and the statute from Mark and Francesca, Scott is going to look at some more recent cases and start to look at the practical implications for the practitioners.
Thank you very much, Alasdair. Thank you, Francesca, for an exceptionally helpful introduction to this talk, and Mark as well for his fascinating overview of the principles that underlie common good law. What I'm going to do today is to take you on a common good journey from an Angus leisure centre via the town square in Grantown-on-Spey to the old harbour of Perth. So we're going to do a sort of whistle-stop tour of Scotland. I'm going to talk about 3 cases. Guild against Angus Council, which is a decision of the First Division of the Court of Session. I'm going to then look at the case of Granton-on-Spey and Vicinity Community Council against the Highland Council. And then I'm going to finish off with Andrew Gray Perth Limited against Perth and Kinross Council and One Call Limited. I acted in the Granton-on-Spey case for the Community Council and in the Andrew Gray case for Perth and Kinross Council. I'm going to speak first, though, about the Guild case. And that is a case where the community were successful in challenging a decision of Angus Council to go ahead with a purported disposal of the Angus Leisure Centre, a leisure centre in Angus, which sat on a park. It had been there since, I think, the early 70s. It was falling into a bit of a state. The council took the view it needed to come down. They also took the view it wasn't common good. Therefore, they didn't need to consult. Before the bulldozers moved in, however, the local community managed to scrape together enough money to raise a challenge, and they were successful in that challenge. And the case illustrates a number of points, particularly with reference to section 104 of the 2015 Act that Francesca covered. For that duty to be triggered, there has to be a disposal or a change in use of common good property. So for the consultation duty to kick in, you've got to have a disposal or a change in use. The legislation doesn't talk about alienation, albeit that section 75 of the 73 Act does, but it seems to me that given the broad approach taken by the court here, that an alienation is also disposal for the purposes of the consultation duty. Well, long story short, as Mark alluded to, the Court of Session took the view on appeal that if you build something on common good land, then that something also becomes common good. So even though the leisure centre was built, I think, possibly after the end of the boroughs, nevertheless, it was built on a park, which was accepted to be common good. So the principle of accession, which we get from Roman law, it means that that became common good land. I had occasion to look at this for another local authority a while ago, which related to a boat that had been fastened, concreted onto a harbour, which was part of the common good, as a display, and it was falling apart. And the issue there was, had that exceeded to the harbour? Because if it had exceeded to the harbour, then if you're going to demolish the thing and knock it down and what we suppose take it to the breaker's yard more accurately for a boat, you'd have to consult over this at the end of the day. So there are these cases where accession comes up. It's a fairly obscure doctrine of Scots law, but it does come up, and this case illustrates quite squarely an example of a building exceeding to the land. So first of all, the Court of Session said, yes, this is common good. And of course, that gets you into the next issue, which is change of use or disposal. Is demolition a disposal? And the court was quite clear that yes, demolition is a disposal, particularly because the council were proposing to take away the leisure centre that people like to use and was important to the community. That fed into the notion that this was a disposal. There'd be nothing left. Not all disposals, not all forms of demolition are necessarily disposals, though it's fact sensitive. But that was an obvious one in the view of the court. Could it have been a change in use? Well, in a sense, it's also a change in use because you're knocking the thing down and you're returning it to green space. But what the court did there was to essentially put forward the proposition that to assess whether you have a change of use for the purposes of common good consultation, it's a mixed question of fact and law. And as Lord Mingus says, with a dose of common sense, and he calls that a dangerous commodity, of course, as we often know, common sense in the law aren't speaking terms. And he took the view, for example, if the local authority had in a park, let's say a tennis court, and they were going to change that into a squash court, is that a change in use? Questions of degree. He took the view you have to approach matters with a degree of sensitivity to the facts to ascertain what in fact is a change of use. But on no view here could it not be said this wasn't a change of use, again, because you were taking away a building which was in use, albeit dilapidated, and leaving green space. That was a change of use. So the court is likely to interpret disposal and change of use very broadly under Section 104. And that really flows from the fact that both the Lord President and Lord Mingus were very clear that this is all about transparency. The Scottish Government documentation leading to the bill and the explanatory memorandum and discussions in the Scottish Parliament all make it clear that this is about transparency and involving communities in important decisions relating to the common good. So the court takes a broad view of Section 104 and a broad view of what a disposal is and a broad view of what a change of use is for the purposes of deciding if Section 104 kicks in. So the court ultimately counsels local authorities almost, in my view, to say it's better to consult even when you don't have to, just to square off the possibility that you might be in breach of Section 104. And I certainly know a lot of local authorities do consult in cases which, strictly speaking, might not require Section 104 consultation. There are other aspects to Gill that I want to touch on. And in particular, that's with reference to the guidance and the types of publicity that the local authority might engage in terms of advertising a possible consultation. And when I say the guidance, I want to emphasize one thing. It's statutory guidance. So as Francesca says, you have to have regard to it, must have regard to it. Doesn't necessarily mean you have to follow it, because have regard to is discretion. But it's fair to say that if you don't have regard to it, you're going to open yourself up to potential legal challenge. And I'll illustrate that with the Granton case. And if you depart from the guidance, then unless you've got a good reason for departing from the guidance, that can open you up to a legal challenge as well. So although it's a discretionary provision, it's not an unfettered discretion. Now, what does have regard to? Well, when you get my notes for this in the next couple of days, it's replete with all sorts of obscure case law references, which I like bunging into these things. Have regard to involves a greater degree of consideration than merely to consult. So it's not lip service. It's something that's got active, substantive content. And if you're going down the route of consultation, let's say you're a local authority and you're aware of guild and you've identified that you've got a disposal or you've got a change in use, then you have to follow the principles of an adequate consultation. Now, the leading case on this has got nothing to do with common good. It's an English case from 2014 called Mosley from the Supreme Court. The consultation must be at a time when proposals are still at a formative stage. The proposer must give sufficient reasons for any proposal to permit of intelligent consideration and response. Third, adequate time must be given for consideration and response. And finally, fourth, that the product of consultation must be conscientiously taken into account in finalising any statutory proposals. Now, Mosley was to do with local government finance in the London Borough of Haringey, so it's got absolutely hee-haw to do with Scottish common good, but it's accepted as being the UK Supreme Court's statement of what adequate consultation means. And these principles, which are sometimes called the gunning principles, are certainly part of Scots law, at least when you're dealing with statutory consultations. And of course, this is a statutory consultation. So these tests are important. So although Section 104 tells us in express terms you have to consult and leaves a lot of that to the local authority's discretion, Mosley tells us what the content of the consultation duty actually is. So, having set that up, there are perhaps one or two points I want to conclude on in Guild, and that is to say that if you are looking to persuade the court to grant an application under Section 75(2) of the 1973 Act, an important part of the consideration for the court will be, have you consulted with the community? Now, interestingly, there's nothing in Section 104 that says you need to consult before you go to court. It seems to me that you could go to court and then consult thereafter, but I'm not sure many local authorities do that. And it certainly seems to me to be the better practice that you do your Section 104 consultation first, and then you can say to the court, this is what we did, this is who we asked, these are the views that come back, particularly if those views are supportive of what you want to do. And they're not always supportive of what you want to do. But it's important that the court is aware of the consultation that's taken place. And I would suggest it's important that you do consult before going to court, because the court may take the view, well, we're not going to listen to this application because there's not any evidence that you've consulted. And there was at least one case decided before the 2015 Act came into effect relating to the low green at Dumbarton, where there had been a lack of consultation, and the court took that into account as a common law consideration. The last couple of points I want to make are the Lord President's observations in relating to disposal. He says at paragraph 3 of his opinion, Section 104 of the 2015 Act applies when a local authority is considering disposing or changing the use of common good property. The question of what disposing means within this particularly statutory context. Although one attractive approach would be to regard it as the equivalent of disposing, conveyancing term, by way of sale, gift, or perhaps even lease, ultimately the interpretation would not accord with the intention behind the statutory provisions. That intention, broadly stated, is to require consultation when an important decision is to be taken about the continued use of common good land. So it's a broad concept, disposal. It's not this narrow conveyancing context. And lastly, and I think interestingly, for a range of reasons, it seems to me, and I could be wrong, I frequently am, that there's nothing in the 2015 Act that says that the consultation is only about common good in relation to which a question arises under Section 75, subsection 2. It just says common good. Now, those of you who are geeks in this area will know already there's a distinction between alienable common good and inalienable common good. There's nothing here that suggests that the consultation duty is limited to only those types of land that are inalienable forms of common good when a question arises. And it seems to me the cautious approach, again, is it's always better to consult to square that off. The downside of consulting, if you don't have to consult, is that once you embark on a voluntary consultation, the gunning principles arguably apply to that. So you can set yourself up for a whole range of legal hurdles you might not have to clear. Although there might be a case coming up shortly where that point might be considered in a judicial review. Okay, well that's Guild, that's Angus. So let's head up to Granton-on-Spey. This was a case brought by Highland Council. It related to the town green at Granton-on-Spey. The council wished to appropriate part of the common good of Granton-on-Spey by charging for farmers' markets and similar activities on the town green. The subjects were gifted to the council in 1966. There were no particular words in the title restricting the purposes of it, but by agreement, it broadly been used since 1966 as a general community space. People met there, held events there, the market was held there, and so on. So it had about 10 years of life, as it were, as a common good asset before the 1975 Act, 73 Act kicked in 1975. I was instructed by the Community Council to advise them, and I carried out quite a significant adjustment to the pleadings, focusing on the consultation process. And my argument essentially was it was wholly inadequate. Consultation process was inadequate in a range of ways. The publicity was poor. the consultation responses were not dealt with adequately by the council, and there was a lack of reasoning as to why the council went ahead with the proposed application to the court. The background here is that the officers of the council did not support the application. They had prepared a report to committee saying, we've considered the consultation responses, community are kind of against this, it's not going to raise much money for the council, it's marginal if it raises any, so cost benefit, we're not supporting this one. But notwithstanding that, the committee went ahead to say, well, we are going to appropriate it and we're off to court to do that. Now, Section 104, as Francesca pointed out, talks about the duty to publish, but how you go about publishing is a matter for the authority. You've got statutory duty to consult, you have to consult with the Community Council. That's all great, but it's the guidance again that fleshes out what publication it looks like. So, for example, as the guidance says, the local authority should ensure that the public should be able to view any proposals for the change of use or disposal on its website, which Highland Council did. Should also ensure that members of the public can view the proposal in person at council offices, libraries, etc. Perhaps hold public meetings if it's likely to affect a large number of people, and put a public notice on a building or land or an object close to it where the public can see it. And lastly, the local authority should aim to consider its responses within 8 weeks. Now, there's nothing in here that talks about a duty to give reasons, and there's nothing in here that's absolutely obligatory on the authority to do any of these things. It's all about guidance, albeit it's guidance that's framed as should do this, should do that. So it's kind of high-end guidance. And the view I took, having looked at the papers, was that all that seemed to have been done here was that the proposals had been put on the website. Not everyone uses the internet these days, but quite apart from that, it had been intimated on the statutory consultation, and that was the sum of it. And there didn't seem to be any evidence of the proposals being put up in the local library or a notice being put on the site or near the site. So, departure from guidance, what was the basis for that? And interestingly, one of the comments made by officers in the report was that there had been a poor consultation response. There's maybe a link there between you haven't published it very well and you don't get many people saying anything in their consultation response. Who knows? Anyway, so first point was publication, inadequate, arguably, which is also a failure to have regard to the guidance, or at least if you've had regard to it, what are the reasons for departing from it? And those reasons have to be clear reasons, according to the Supreme Court. In a housing case from 2015, departure from guidance must be based on clear reasons, objectively proper and legitimate reasons. So, again, a practical point for local authorities here, and also for people who challenge local authorities: has there been regard to the guidance? Have things not been done that are mentioned in the guidance? What's the justification for that? In particular, if you're a local authority, can you provide a clear reason why you've not done something in particular? For example, you've not held public meetings. You might take the view that the proposal is not going to affect that many people. That might be a reason for not doing that, but you have to address your mind to these things. Conscientious consideration. You might remember that's the fourth part of the gunning principles. The product of consultation must be conscientiously taken into account in finalising any statutory proposals. What did the council minutes say? The council noted and balanced the representations received together with responsibilities for the Granton and Spey Common Good Fund in order to decide whether to agree the proposal should proceed or should not proceed, and then agreed to proceed with the process to introduce mandatory charging for the use of the square in Granton and Spey. That was it. Notwithstanding, there were people saying in the majority, we don't want this to happen, and notwithstanding that their officers were saying, we don't support this proposal. Now, there is no duty to give reasons in the 2015 Act, or indeed the Section 75(2) of the 1973 Act. But it seemed to me, drawing on general public law principles, and certainly a lot of recent case law on the duty to give reasons, that the position of there being no general duty to give reasons at common law is probably not the law anymore. It's probably, there is a duty to give reasons in most cases, unless there's a reason not to. And we see that from a number of judicial review cases where the court has emphasised, in particular, where a decision appears to be aberrant. No one wants this. Your own officers don't want to support it, but you go with it. Now, you might be able to give reasons for that, but you haven't provided them. So the evidence that was before the committee didn't support the conclusion. And the court may take the view that's a lack of conscientious consideration. Remember, this is about transparency, according to Guild. And once you're into the territory of transparency, then it's a lot easier to argue there's a duty to give reasons for a common good decision. Now, if the committee had weighed up the objections and the committee had regard to the officer's concerns, but nevertheless came up with a rationale for not following those concerns or those objections, then you could say they've had conscientious consideration because they've applied their minds to it. But absent that link, it's not there. So that was a reasons point. The upshot was, when the adjustments went in, the white flag ran up the pole. And although I'm not sure if anyone's here from Highland Council might yell at me, but the council put out a very nicely worded press release saying that, I think some gentleman here from the Community Council might remind me, but effectively it was, we've thought about this a bit further, and we're not going to proceed with this for now, and the application's withdrawn. Notwithstanding that, we got our expenses from the Sheriff and Sheriff Court proceedings, and that included paying for my services. So there was a financial cost as well to the council going about this in what I thought was a fairly casual way, without proper regard to these broader public law principles which underpin common good. So if this common good is not hard enough, you now have to think about public law principles that underpin common good. Now, conscious of time, and I can mention this last case very briefly, it's a relatively short point. Andrew's going to mention as well in his talk. Down in Perth, across here from Perth rather, I'm from the west of Scotland, so my geography is rubbish for the East Coast. You've got the old harbour of Perth, which is broadly now an industrial estate. But it was medieval originally, and the title is a jigsaw. On this industrial estate owned by the council, there were a couple of businesses. One of those businesses was effectively a haulage firm that wished to drive its big trucks up this narrow lane to get to its premises. And one of the other businesses on the site that the council had leased a unit to, I think, was a sort of body shop, car repair place. They were saying, you can't do this because these lorries are far too big for this ancient lane, and it will knacker our premises, it will bump into things, and that's not happening. Well, Andrew Gray, the pursuers, raised an action at Perth Sheriff Court, seeking a declarator of a number of things. Servitude. There was a servitude created by prescription. There was also a servitude of necessity, but they also threw into the mix, and that's where I came in, common good argument. That's why the council were convened as defenders, that the council had failed to demonstrate how they'd had regard to the duties of the inhabitants, meaning the pursuers, in granting the lease to the Unit 1 Call Limited. It's quite a convoluted argument. And that was a way of bringing the council into the action as well, and putting pressure on the council to possibly terminate the lease to the unit. The argument being impliedly that there was some breach of common good duties underlying this. Now, I took the view fairly quickly when I got instructed that this has got hee-haw to do with common good. It's a property claim. Servitudes and common good are different things. There's a case from 1859, Sanderson and Lees, which says that common good is not a servitude, and there's a confusion there because I think some people think common good is a form of servitude, it conveys property rights that can be enforced. It's nothing like that. So that formed the basis of a note of basis of preliminary plea. The other main argument there was that if you're going to challenge the actings of the council by complaining about how they may have exercised their discretion in granting a lease with regard to section 15.4, having regard to the interests of inhabitants, that's judicial review territory. That's not for the sheriff to deal with in the sheriff court. And there was a plea to the competency of that part of the action as well. So I threw in the works into this one because the council were taking the view quite rightly, this has got nothing to do with us. We don't want to be drawn into this potentially very expensive sheriff court proof about an access right over property that, okay, we own it, but you know, it's not our problem at the end of the day. And on that basis, the case was heading to debate. And again, it's a bit of a pattern here. The white flag went up and the pursuer said, you got me. All this common good stuff is coming out. And thereafter, the case settled. So interesting to see the ways in which common good sometimes bleeds into other areas of property law. We don't, of course, have a judgment in this case, unfortunately. You've only got my word for it. But I have set out the arguments in some detail in the notes to set out what the issues were, what the analysis was, and the outcome, as I say, seems to be an acceptance that there was force in the point made that common good and servitudes are different things, and really, why have you brought my client to court? So thank you for listening to that. Notes will be available shortly. They are absolutely guaranteed to send you to sleep very, very quickly. And if nothing else, I commend them to you for those reasons alone. Thank you.
Thank you to speakers. We're well up to time, so there will be some time for a few questions now for these speakers, but with a word of warning, I don't want to have Scott cross-examined too harshly on the Guild case just yet, because I know that Andrew Ferguson may have slightly different views on it from a talk I heard him give previously, and in support of the dissenting opinion of Lord Malcolm. And I also have a passing interest in that case, having acted for the petitioners unsuccessfully in the outer house and been usurped by COVID and senior counsel to be told the right answer in the inner house. But if anyone does have questions at the moment, we've got probably 5 minutes for questions now, and then we're going to have a coffee break and then return for Rob and Andrew. So does anyone have a question? Yes.
Seriously, I do mean that. That's my that's how I tend to start with these things. Kind of in what Mark and Francesca were saying, that it's to do with intent broadly. There are things that are classed as inalienable common good at common law. So, for example, town hall is almost certainly inalienable common good. Yeah. In days of yore, things like the case involving stables for police horses, so way back in the 19th century, that's part of the apparatus of the borough. That was common good. So things that are essential to the dignity of the borough, the efficient running of the town, common law would be regarded as inalienable common good. Where there is clear words of grant, so dedication to a purpose which would be regarded as common good. And by common good, of course, we're getting at things which have a community purpose, a public purpose. So a title deed that referred to the grant of land for purposes of the provision of a park or a place of entertainment or for recreation, that sort of thing tends towards inalienable common good. If it was simply a grant of land to the borough, the title alone would not say it was an inalienable common good. You'd have to perhaps dig into the background. So, for example, if local laird had gifted land in 1860 to the council or the borough, now, and it had been used ever since as a park, then by dedication through use, it would become an inalienable common good. But if it, from 1860, had been used as commercial site for the council, it wouldn't be common goods.
If it's similar principles, sorry, if it's alienable, does it mean that the council can't dispose of it, or can they dispose of it if they go into the whole procedure section 675?
Yes, you
Can
can.
dispose of
You
it.
can. And I should caveat this slightly because section 75(2) says that if a, where a question arises, is a test. And that gives local authorities a bit of wriggle room, because you can get cases where it has been inalienable common goods, but the council might say that it no longer is, so a question does not arise. Now, that would allow the council to lawfully say we don't need to proceed to court. Equally, section 75(2) doesn't actually say that even if the question arises, you have to go to court. Some discussion in case law about this. So you can get these cases, and I can illustrate one case where it's a harbour, a pier more accurately. And this is an unusual one because in 1890 something, the Board of Trade, I think it was, got involved in passing a piece of local legislation which gave to this particular borough a pier, and it said in the statute, this is for the common good of the borough. And I find that quite unusual to have a statute actually dedicating something into the common good, but obviously it happened. The issue in that case is that the pier's not really been used as a pier since the 1960s. It's a physical pier, but it's used as a car park. So on the face of it, it's inalienable common goods. But since, the 60s, it's been used as a car park. And that's arguably use that's referable to the roads legislation. So has that now lost the character of being an alienable common good and has become something that's alienable common good? So that's a case where I'm currently thinking about, can I say to the authority, a question no longer arises because no one uses it as a pier anymore?
Right, Scott, would it be fair to say, Scott, the more recent cases have tended to go along the line that if it was once inalienable, it is probably likely to still to be inalienable, even if it's been unused as purpose for decades. And moving in that direction is unfair.
I think so. I think it's probably part of this general view from the courts. We don't get a lot of court cases in common good, but as far as we get any cases, particularly from the Court of Session and the Inner House, they seem to be quite strong on the local authority being custodians of the common good. That's not the words of the courts, that's my word, but this emphasis on common good as an asset for the benefit of the community. And so I think if you're a local authority and you've got a case where you take the view it's no longer an common good, you're going to have to have quite good evidence to show that, rather than vague suggestions that just fall out like that. Common good, it has to be evidence.
Is anyone else? Yes.
I think it would. I don't have. I think what would probably most important would be what was the source of the capital funds. If the capital funds, it would depend, I think, on what was the source of the capital funds. I mean, if the capital funds had come from the sale of inalienable common good land with the authority of the court, then if that has just simply gone into a capital fund, then I think that is, it must be questionable. It might be whether that is now something which is alienable, movable property because of its source. That seems to me to be the position, but I'm not at all certain. I think it would depend upon where the common good funds had come from. I think that's what's probably most important.
Yeah, I think it's not an area I've looked at in a while, but it seems to be broadly to be more likely it's viewed as a local authority accounting exercise. Because you've got the duty to have regard to in terms of administering the funds, if you want to use some common good money for a non-common good purpose, you have to have regard to the fact that it's derived from the common good as a consideration in the balance of competing financial considerations. So you might be less inclined to use it for non-common good purposes. But there's nothing to say that you can't. But it has to be resolved, and again, I commend Mr. Ferguson's book on this point. It has to be resolved, in my view, as an exercise of local authority to finance rather than disposing. Spending common good money in itself is not a disposal, putting it at that level, but administering it will still have this common good character.
Yeah, I understand Andrew's going to cover this a bit in his talk later, so we can hold that thought to the end of that. But do we have any other questions for any of these three speakers before coffee? Well, if you do think of anything now or over coffee, just note them down and there'll be another chance for questions at the end. We're going to take a coffee break now until about 25 to 4, so about 20 minutes. Thanks.